afternoon to introduce Professor Stephen Green, who holds two positions at Willamette University. He's the Fred H. Paulus Professor of Law in Willamette's College of Law, where he teaches constitutional law, First Amendment, legal history and jurisprudence, and criminal law. He's also the director for the Center of Religion, Law, and Democracy, which is one of the interdisciplinary centers of excellence at Willamette University. And he teaches legal history and American religious history in the College of Liberal Arts. Professor Green also holds two doctoral degrees, a JD, which is law, and a PhD in American constitutional history. He has an MA in American religious history and a BA in history and political science. He's the author of 3 books and many articles on religion and legal issues respecting religion. So by virtue of both his education and his scholarship, he is well qualified to address his subject today, which is the changing face of church-state relations. No, it is not about Salem. If some of you came for a tour guide, no, he's not going to do that. It's a different subject. This talk will trace the evolution and explore the newer controversies that have emerged in this area of church-state relations in the United States. Now, I have one more thing to say that's before I turn the mic over to Professor Green. Professor Green's wife went out of town. He has to pick up his daughter, which means he has to leave at 3 o'clock. He may or may not take a break midway through, but there will be a place where he transitions. So this will be a little bit unusual this afternoon. This came up and we have to just deal with it. Professor Green?
Thank you. It's nice to be back at ICL. And speaking of the break, if someone wants a break, just hold up your hand and let me know, okay? We'll see. There is a natural place to make the transition in the presentation. Okay. It's been several years since I've talked to this group. I always enjoy talking to this group. I actually get better questions from you guys than I do from my students most of the time. And when I was asked to do this again, actually what first came to mind, since it had been several years since I had done this, is to a degree how much has changed. And I didn't want to give kind of the same presentation that I've given in the past. I mean, to a certain extent, very little changes, but then there are always nuances that seem to make us think we're witnessing some significant change in what the issues are that we're confronting. I've been involved in this area I guess you could say going back to 1985 when I entered graduate school, and I knew that I wanted to study church-state history, so that's quite a period of time. As Bob mentioned, I approached this issue from various perspectives. I'm a historian, and most of my scholarship is in history. Actually, most of my scholarship is in religious history, to the chagrin of my law dean, who would like for me to publish more legally oriented manuscripts. But that's really where my interest is and where I think I can offer something to advancing scholarship. And so I approach these issues from a historical perspective and be happy to also put this more in historical context if people have questions about that. My last book was on the issue of America being a Christian nation, which is something I've talked about a fair amount, but that issue just seems to always continually come up. About our religious heritage, and I'd be happy to answer any questions about that. I'm not planning on concentrating on that today. The book that I have waiting my publisher right now is on the history of church-state development between 1940 and 1970, kind of the introduction to the modern era. So usually my scholarship, I'm approaching it from a historical perspective. I also teach constitutional law, First Amendment, and church and state. And actually one of the things that I've realized, this is my 17th year at Willamette, and I taught some of these areas before. When I first started teaching the legal perspective, the legal issues surrounding church and state First Amendment, the issues were kind of the old bread and butter issues, which I think most of you will be familiar with, and actually what I cut my teeth on. And I realized over the last several years, I was needing to revamp my syllabi, because a lot of those issues were just, not that they were no longer relevant, but they just weren't hot button issues anymore. They weren't kind of the confrontational issues that we've actually seen in the last 15 years or so. an evolution into different types of issues affecting church-state relationships. And so I will talk about that somewhat as a church-state teacher, scholar. My third perspective on this is that I'm an advocate. I didn't mention, but for 10 years I served as legal director of a First Amendment organization in Washington, D.C. called Americans United for Separation of Church and State. I just, this last Monday, I think it was, Monday, participated in an amicus brief at the United States Supreme Court in one of the cases I'll be talking about. That's probably, I think, about my 30th case at the Supreme Court that I've been involved at one level or the other. So I'm an advocate, and I take a distinct position on these issues, which will probably become self-evident in my presentation. So I have a well-rounded, if you want to think, way of thinking about these issues. So what I do is I want to get into some of these, and then certainly have time for question and answer, because many times the things that I'm thinking about may not be the issues that everybody else is as interested in. So why don't we proceed? Okay. Various issues with church and state. Some of these are the traditional issues, and we'll get into many of these, right? Probably the first major issue, going back to the early 19th century, which I've written about church and state. Well, let me back up. Many of the first church and state issues, at least within the life of the United States of America. There were clearly church-state issues that preceded that, but like I said, I wasn't going to talk about the revolution and the founding. Surrounded religion and education issues. That you had the creation of the nation's common schools in the beginning of the 19th century, and those common schools were at least initially highly skewed toward Protestantism. They were seen as reaffirming Protestant values. Vast majority of the teachers in the common schools were in fact ministers or had some type of religious education. And the general consensus was that we could not have education without having moral education. We could not have moral education without having religiously based education. And the public schools, as one of their main duties, was to teach moralism, character, and even to teach religious fealty. And so some of the first issues dealing with church and state in this nation have surrounded religion and public education. And those still exist. I don't want to basically say some of these issues have gone away. They still exist in many instances in many parts of the country. But that was really kind of the first major issue dealing, and it has several different aspects of it. Curriculum issues, we're going to talk a little bit about evolution, intelligent design, and now we're starting to see them go into areas that probably no one ever thought of would involve a religious question in public education 20 years ago. That now we're talking about, is there a religious question that is raised when someone is talking about sex education? Or if you're teaching gender equality in public schools, does that then have some type of religious question that's associated with it? And so we're starting to see religion kind of work its way into issues in public education that heretofore we had never seen as, or never thought of as raising actually a religious question. That's going to be some of the new things I'll be talking about. Okay. The other big issue that was the traditional issue was the public funding of religion. And again, that arose initially, and for many years, the chief area of concern for that was, again, funding of education, and in this sense, funding private religious schools, parochial schools. That really came into being, I would say, around the same time the common schools were founded. Even though we did not have the great influx of Catholic immigration until beginning in the 1840s, certainly once that occurred and the creation of parochial schools within the United States, that Catholic officials went and requested a share of what was called the common school funds, saying that, well, your schools, your public schools are pretty Protestant-oriented. They read the King James Bible. You have Protestant-oriented catechisms. You have, other things that very much influence children toward a Protestant perspective. And so give us money for our schools. Give us money for the Catholic schools. And so these issues were highly litigated, both in the courts and just within the public arena, really beginning in the middle of the 19th century and continuing up until very recently. These were some of the major issues with church-state. Okay. Now they've morphed into more kind of sophisticated issues, things like vouchers, tax credits, and then something I'll talk a little bit about, religious social services. Okay. Then we have some other issues, what I call ceremonial deism, Ten Commandments monuments in public squares, crosses in public property, nativity scenes. We're about ready to enter into the Christmas season. And when I was practicing in Washington, D.C., it wasn't that I hated the Christmas time, but I guaranteed I got at least one phone call a day within the 6 weeks preceding Christmas about, you name it, every single host of question about this nativity scene in this public square type question, right? So these have been around for a while, but there's some new versions of that. And then we'll talk about religious discrimination, in a sense, part of what we call free exercise of religion, but how that's changed. And then end with talking about religion and politics, which is an old favorite, I think, for a lot of people. Okay. All right, the first sources of authority. I'll try not to get too wonky or too technical as a lawyer, but we do understand we're talking about constitutional principles. And to a certain extent, that's where some of these battles take place. But many of the battles don't really take place on a constitutional or legal level. They just take place in the public square with disagreements. So many times these issues take on both a social dimension as well as a political dimension as well as a legal dimension. And sometimes resolving one does not resolve the others. And in my experience and also my study, I can tell you many times there's a high degree of inconsistency sometimes between maybe a legal holding and then what the reality is on the ground. That's just something we always have to live with. But again, these are at their base constitutional issues. And so you have to look for sources of authority. And of course, the main source is the First Amendment to the Constitution, written primarily by James Madison, and it has two parts to it that we're of concern about. The part that says no establishment of religion, and there's a big debate over what that means. There has always been a big debate. I necessarily don't want to get into that, but I'd be happy to if people want to in questions. But there were issues about, in essence, the government's support of religion. And should government be supporting religion? Should religion be involved in governmental activities? Those are questions dealing with the Establishment Clause. Okay. The second clause is the Free Exercise Clause. And that is the one that basically says that the government cannot impose burdens on people's ability to exercise their religion. Right? But there are two other clauses in the First Amendment that actually have come into play more recently. And that is the Free Speech Clause, and I'll get to, and then the Freedom of Assembly Clause. Because we understand that, of course, many of the ways that people exercise their religious faith is through communities of believers, through churches, synagogues, etc. And so as a result, there are these issues about, can I associate with people with who are like mind without the government interfering with my ability to do so, right? Particularly if it's on a religious level. So these all interact in some of these cases and some of these controversies. We also then have state constitutions. Like I said, I apologize, this is the wonkiest part of the presentation. State constitutions. Every single state has comparable clauses in their state constitutions, like the Free Exercise Clause, like the Establishment Clause, like the Free Speech Clause. Right? And so whenever an issue comes up, sometimes you may litigate it, or sometimes what may be controlling is what's the state constitutional provision. Sometimes it's what the federal constitutional provision is. We have dual federalism in this country. Depends on where you bring the case. Most lawyers will, particularly if they're in state court, will argue both federal and state issues because they can rule on either of them, but generally when you're in federal court, you only argue the federal constitutional issues, which is the First Amendment. 37 of these states have what we call, or some people call, Blaine Amendments, and Blaine Amendments are more specific provisions in the constitutions that expressly prohibit the funding of religious institutions, more specific than what the Establishment Clause does. The Supreme Court has read into the Establishment Clause a no funding principle, but it's not expressed in the Establishment Clause. 37 states have express provisions. Oregon is one of those, which basically says you cannot fund religious institutions or fund sectarian activities. And so those sometimes are controlling. And then we have federal and state laws, which also might be effective. And some of the controversy going on these days is that the federal government has passed a couple of federal laws that have some sweeping qualities to it that seem to be protective of free exercise of religion, potentially at the expense of non-discrimination laws. Those are what are called Religious Freedom Restoration Acts, the RFRA, And then, not quite as related, be the Religious Land Use and Institutionalized Persons Act that deals with zoning issues primarily with houses of worship. The bottom line is what I'm getting at is that when these controversies come up, there may be various touchstones that are there so far as how are we going to resolve this question, both legally but then to a certain extent socially when it comes to these questions. Okay. All right. So let's talk about religion in public education real quick. This is by far probably some of the most familiar areas of controversy. I would surmise that potentially many of you, if you were in public school, you're old enough and you probably had some form of religious exercises in public education, right? I was in public schools in the late 60s and 70s, so I'm maybe a little bit younger than some of you. But then I was in public school in Texas. And what that meant was 20 years after the famous Supreme Court decision in 1963 saying public schools cannot have school-directed, school-sponsored prayer and Bible reading in public schools, we in Texas said, we don't care what the Supreme Court has said. We're still going to have prayer and Bible reading in public schools. This was a highly contentious issue. You had, in fact, they even used some of the same terms that they used against Brown versus Board of Education, the famous desegregation case from 1954. That many places, it's not just, I shouldn't beat up on the South. I'm a Southerner, so I get to beat up on the South. But it wasn't just in the South, but still many places, rural places in the Midwest, as well as the South, that many school boards, which are popularly elected institutions, basically said, we don't care what the Supreme Court has said. We've never had a problem with prayer and Bible reading in the public schools. No one has ever complained about it before. So consequently, we're going to continue to do with what we have always done. Of course, without knowing that there's always been some degree of religious dissent, but people many times would not be outspoken in this religious dissent. Right? So I was working for Americans United in the 1990s. So I was working more than 30 years after the Supreme Court decisions dealing with prayer and Bible reading in the public schools. And it still amazed me how many cases I was contacted with which were almost replicas of the Supreme Court cases in 1962 and 1963. How pervasive it was in many parts of the country where you still had ongoing prayer and Bible reading in the public schools. I can remember going to Central Pennsylvania. I've been contacted by some parents that they had in this small community in Central Pennsylvania. Prayer and Bible reading in the public schools, over the public address system. All children had to stand and participate in the prayer and Bible reading going on. My colleague from the organization who was from Pennsylvania came with me, I think to protect me. The reason he says, you understand, Central Pennsylvania is like Mississippi between Philadelphia and Pittsburgh. I shouldn't beat up on Mississippi, but anyway. We went, and I went and talked to the parents and the potential plaintiff who were complaining about this, and then there was a school board meeting that night, which was solely to discuss this issue. And I made a presentation and an argument before the school board for why they had to change their practice. And I was threatening legal action. I had a local counsel ready. We were ready to go in and file a lawsuit within the next week or so. Well, they clearly felt they had a gun to their head. And so they grudgingly changed the policy. It was a packed audience, of course, you can imagine, packed audience. And they grudgingly changed their policy. I mean, I explained to them that, as lawyers, we think of something called precedent, which means, is there an existing case that seems to be on point? How close is that case to the facts of this new case that's presented? And I said to them, I have never seen a case that has closer precedent than this does. The Supreme Court decision that struck prayer and Bible reading in public schools came out of Central Pennsylvania. It dealt with teacher-led prayer and Bible reading over the public address system. It was like on every single point. But the school board had been resisting this for more than 30 years. So they grudgingly voted to change the policy. But their response was, well, Juan, you're an outside troublemaker. And I said, well, no, we didn't come in until we were contacted by someone in the community who obviously found this somewhat offensive. So obviously someone was objecting to it. Their response was, well, this is the first time we've ever heard any objection to it. Okay. But anyway, so they changed their policy. After the end of the school board meeting, like I said, it was packed, and I kind of wanted to get the hell out of there as quickly as possible. Actually, about a third of the people hung around and said, you know, I complained about this about 10 years ago. And they said, no one has ever complained about this before. Go home and shut up. And that was really the story I heard from so many people, that they had been just pushed aside, they had been minimized for the perpetuation of kind of majoritarian religion in public schools. And so it wasn't like the school board didn't know, but there was just this sense, and I got this argument so many times. It was, you know, we're a close-knit community, we all kind of share similar religious values, you know, why can't you just let it go along? But the problem was, is a lot of people who were biting their tongues, biting their cheeks, that they were being introduced to some type of organized, directed religion in public schools, which was not of their faith tradition. And therefore, it forced their children to either go along, to compromise, or to object, and then be sent to detention hall or something to that effect. And so these issues still continued. By the way, one more last story about this anecdote. As I was walking out of the school building, I did have a couple of guys come up to me and start kind of bumping me on the shoulder and said, "You're going back to D.C. tonight, aren't you?" And it was like, 10 o'clock at night. And I said, "No, I don't think so. Are you staying in town?" And no, I wasn't. So I was staying in a town about 20 miles away in a motel. And I wasn't about to tell him where the motel was. That is really the first time that I ever got my flashlight out and checked under my car, just to make sure that my car was okay before I drove away. And my colleague and I, we just kept looking in the back rearview mirror to see if there were headlights following us out of town. People take these issues seriously, because many times they believe that the public schools reflect, again, their sense of community values and morals. And I respect that. But the point is, there are other ways you can communicate values and morals. Okay. Most of those issues have gone away. Okay. We still find some isolated cases in parts of the country where you still have violations of clear Supreme Court decisions about prayer and Bible reading in the public schools. But generally, those have kind of diminished. And in fact, in the mid-90s, I participated with the Department of Education when I was in D.C. With the Clinton administration in helping write some guidelines about what was permissible forms of religious expression in the public schools and what were impermissible forms of religious expression in public schools, such that we could find some common ground and not always kind of fight over these contentious issues, but realize there are some areas where children can engage in forms of religious expression. And to a degree, I think that actually went a long way. This was distributed to actually every single school district in the nation. And I think it was a learning experience for many that there are ways that we can say children can express themselves religiously without necessarily being forced upon them by the schools. As a result, we've seen most of those cases kind of go by the wayside. There are very few, what was a bread and butter case for so long. Still questions arise about religious instruction sometimes. I'll get to the new versions of that. Moment of silence was kind of a way of getting around vocal prayer in the public schools, so long as it's not a moment of silence for prayer only. Okay, all stand for the moment of silence and bow your head. Well, that's not going to work, okay? But if you say a moment of silence to contemplate the day, if you want to pray, you can, then that would be all right, okay? And then there's always been controversy about how you go about teaching about religion in the public schools. I just may save that for a question if anybody has a question about that. It gets very technical. And then the old nemesis about whether you teach, if you teach evolution, can you teach something that's the counter to evolution, creation science? And the Supreme Court is very clear, no, you can't. Creation science is not science, it's religion. Evolution is science. So consequently, you can teach evolution without teaching the religious equivalent of it. Okay. Well, these are kind of the old issues. The newer issues that come up within religion public education are things like Bible clubs. How much do we allow students to do these things on their own without the direction, the organization of school officials? So can there be, if there are student voluntary clubs, non-curriculum clubs in public schools, can some of those clubs be Bible clubs? And Congress actually enacted a law to that effect in 1984. It was upheld by the Supreme Court in 1989. And to a degree, I think it's a good law. It makes sense. If students want to be religious, let them be religious in a club period before or after school. That's fine. Don't force kids to go to it, so the kids who want to be religious can be religious. The other kids can be howling atheists, whatever they want to be. But they don't have to participate in this. The question, though, becomes whether it truly is student-initiated, because many times you have teachers who have a religious inclination and they want to sponsor the club, they want to participate in the club. Many times these clubs become fronts for local church groups, youth ministers who want to come in and use the club for evangelizing purposes. So it's one of these situations where you actually have, I think, a law that makes some sense, and if it's done, I think, with the appropriate intent, is a good law. But it does open the door to some type, I think, of misuse sometimes that goes on. Intelligent design is the latest version of creation science, which is basically a watered-down version of creation science, basically saying you teach about intelligent design, that we don't know if it's God or not, but something looks like has organized the creation of the universe, and teach that as an alternative. Never went to the Supreme Court, but a court in Pennsylvania, of all places, struck that down about 10 years ago, saying, no, that's also religion, too. You can't do that. But we do continue to see, though, there are a couple of big anti-evolution groups, both on the West Coast, that get a fair amount of mileage by going and kind of doing workshops with school boards that may be more conservative and that have kind of the inclination to follow them. So basically say, yes, you can do this. This is okay. And so it's amazing how much you have to keep track of this and continue to remind these school boards, no, this is still teaching religion in public schools. And that's impermissible. But we also then have seen these questions, as I said, come up in things like sex education now, gender equality issues, that you have people who are usually religiously conservative, and they find any discussion about these issues as being against their religious belief systems, such that they want their children either to opt out of various forms of sex education, which can have, of course, a significant health question related to that, and also to not, once again, talk about gender equality within the public schools because they object to these. And so this is where we're seeing more of the agitation these years. Then we're also seeing what I call outsider access, and that is that we allow outside groups to come into the public schools immediately following the school day to teach Bible, teach religion. This is called the Good News Club, which is very pervasive throughout the country, and it's another way of evangelizing kids within the public schools. The bottom line is that kind of the old issue about school-directed organized prayer and Bible reading, which most of us grew up with, that's pretty much died. It's gone by the wayside. Rarely happens anymore except in a few isolated locations. It's become more nuanced now with things like Bible clubs, outsider access, or complaints about general curriculum issues saying it's slanted to be anti-religious, so either you need to provide the alternative religious perspective or you don't teach that. Get this here. Okay. Public funding. The old way was that the Supreme Court had basically said money flowing to religious institutions is unconstitutional. That in essence, when the government funds religious institutions, then the government's supporting religion. It's forcing people to pay taxes to support something they don't believe in. But it also then makes the religious institution dependent upon the government. That was kind of the bread and butter way of thinking about funding religious institutions. No direct aid to religious institutions. That goes back to 1947. Right? Now, they shortly made an exception to that and basically said, if it's for things like school lunches, if it's things for like nurses, if it's health and safety related concerns, then that's permissible because that's for the purpose of making sure the kids in the parochial schools are in fact healthy, get their general needs, but nothing related to the instruction, to the curriculum. That was kind of a nice firewall, bright line that existed for a while. That line before long started to evaporate. And it started to shift more where you could actually then provide instructional materials that would supplement the parochial school's curriculum, so long as it didn't take over the parochial school's curriculum, and it was what we called non-divertible, that it was something that you could identify could not be used in a religious way. So things like textbooks. If it's a secular textbook, the argument was you could give that to the religious school because it's still a secular textbook, that you would be hard to teach religion out of a secular textbook. But things that could actually be changed, manipulated, computer systems, etc., those might be divertible. Right? So one of the last cases I actively was involved with at the Supreme Court in 2000 dealt with a case out of Louisiana which dealt with divertible equipment that was being loaned, is the term. It's never a loan. It's basically, they write it off after a while, so it's a gift, to parochial schools. And I tell my students this, and I love to watch their faces look at me like, gosh, you are really old. I said, when we first filed this case in the mid-'80s, right, which basically gives away how old I am, one of the issues is that they were giving mimeograph machines. Remember mimeograph machines? Mimeograph machines to the parochial schools, and all the parochial schools were affiliated with a church. Most of these were Catholic, but some were Lutheran, with the church on the same grounds. And so you love smoking guns when you're a lawyer. And so we actually had evidence that they were using the mimeograph machines to run off the Sunday bulletins. Okay, religious use, right? The equipment was divertible. And I explained this to them, and they look at me like, what is a mimeograph machine? Unfortunately, this shows you the problem with litigation. This case went through so many different levels. We finally, it was the mid-'80s when we filed the lawsuit. It took us 15 years to get to the United States Supreme Court. By then, of course, mimeograph machines were out the window. But guess what the issue was, of course? Computers. How are you going to keep from loaning computers to parochial schools now, since computers have become so important to the educational process? And that was our Achilles heel, that we realized that it was going to be almost impossible to win on the question about whether you could actually have materials that could be diverted. And what the Supreme Court held in 2000 is, so long as the religious school promises it will not use it for religious purposes, we will not assume that they will use it for religious purposes, so consequently, that may be allowed. So it's been kind of this gradual, ebbing of the rules, but still the basic rule has been, if it is something that is ideologically driven, if it has a religious quality to it, or it can be diverted, and to a certain extent, cash money, as opposed to materials, can be diverted, it can be used for any religious reason. That has been the firewall. Okay. The court also allowed for tax credits and tax deductions over time. If you want to take a deduction on your income tax for giving to a charity, you can. You want to give the charity being a religious institution, you can. That was never seen as being that problematic, but those were some of the older issues when it came to funding. Well, what's happened since then is now the bigger issues are what we call vouchers. And the reason I put vouchers into the different category is, unlike educational material, which has to serve a secular purpose before it can be loaned or given to a religious school, vouchers are cash grants. And vouchers pay for the entire tuition cost to go to a religious school. And so a lot of us felt like that was a very different thing. That's crossing the Rubicon, because in essence, you basically are then allowing for religious schools to receive a per capita, basically, tuition reimbursement by virtue of the parents giving the voucher to the religious school. Okay. We litigated these cases for about 10 years, basically won almost all of them until I went to the United States Supreme Court in 2002. And the Supreme Court ruled 5-4 that vouchers were constitutional, that it was permissible, because they said parents were making the ultimate decision of where their child went to school, and so they were making the decision whether the money would in fact pay for religious education, not the government. It wasn't the way the program was structured. It was the ultimate decision on where the money went that made the decision of whether there was a constitutional violation. And if what we call independent private choice, the parents make that decision, not the education officials of the state make the decision. Then they said it breaks the circuit, was the term they used. It makes the difference that that is no longer government funding of religion. Now, we can have a debate about vouchers one way or the other. There's a lot of policy questions about whether vouchers actually work. I'd be happy to talk about some of that if you want to. But at least from a constitutional perspective, I found that logic to be a little troubling, because you can only exercise independent choice depending on what the alternatives are, right? And a voucher for public education is very much unlike my employer, of course it's Willamette, but my employer giving me a check every month and then say, spend the money how you wish. If you want to spend it on your mortgage, you can. If you want to spend it on a new race car, you can. If you want to spend it on vacation, you can, right? That's independent private choice. I can spend my money however I want to. If you're given a voucher, and the only way you can spend that voucher is on private education, then that places significant limitations on your ability to actually choose where you're going to go. And in the case that went to the Supreme Court in 2002, it was based in Cleveland. By the time we got to the Supreme Court, 99 out of 100 seats were all in Catholic schools. So if you wanted to have a voucher as a parent, you had basically no choice. The only place you could actually use your voucher was, in fact, to pay for education in a private Catholic school. The court kind of ignored the way the program was structured. It basically said it broke the circuit because parents were the ones making that ultimate decision. And so a significant change in the constitutional rule about funding direct aid. The most recent case, which was litigated this last year, called Trinity Lutheran case. I tell people, the Supreme Court, let's put it this way, the Supreme Court has approximately 7,000 to 8,000 petitions every year. Hear my case, hear my case. Okay. They are now choosing 70 cases a year to actually hear. So the chances of getting a case at the United States Supreme Court is so nil. So what does that mean? The Supreme Court gets to pick and choose which cases it wants. And so if they're wanting to make a point, they will often pick a case with either a very, depending on kind of how the justices are already leaning, a very favorable fact pattern to one place, to one side, or a very unfavorable fact pattern to the other side. Has anybody have heard of this case, Trinity Lutheran? Yeah, okay. This is about the most unfavorable fact pattern if you're separationist leaning, which you can tell obviously I am. And this was that this church, which had a preschool, applied for and was granted reimbursement funds to purchase recycled tire material to resurface its playground. Okay. It qualified under most of the criteria. It would have gotten the grants, but then the Missouri Attorney General, who was a Democrat at the time, said, no, we have this no aid provision, one of the 37 I was talking about, that says we cannot give direct money aid to a religious institution, and this religious institution happens to be a house of worship. Now, of course, my reaction would have been, as someone who kind of wants to avoid some of these ultimate conflicts, would say, just give them the money, let's go on to the next case. Okay. But the point is, we're always concerned about precedent. And the precedent is, if you pay for resurfacing a playground on church grounds, what then else can you pay for, right? Can you pay for the repair of that nice 1970s building, right, that's starting to need some major repairs, right? Can you pay for a new air conditioning system? Can you pay for new bathrooms, right, for the kids who go to that school? So where the line is drawn, no one knows. There's actually a case that's pending before the Massachusetts Supreme Judicial Court, the highest state court, which actually deals with historic preservation funds. And if any of you have been to New England, all the beautiful congregational and Unitarian, colonial churches you see everywhere, they're beautiful buildings, and they're all in need of repair. And so in this one town in Massachusetts, the local congregational church, which has this beautiful 200-year-old building, more than 200-year-old, has applied for, renovation funds to basically have the historical commission pay for major renovations of the building. And they've actually gone so far as to say, if we don't get this money, we don't have enough parishioners to basically continue the congregation. We cannot afford this building as a congregation. So getting these funds makes the difference of whether a house of worship continues to exist. And what are they arguing? They're arguing this case. They're arguing that the court held 7-2, that it was permissible to give these funds to Trinity Lutheran Church. And so even though there's a footnote in the opinion where Chief Justice Roberts says, we're not deciding any of the case, all we're talking about is playground recycling. This is the way the law works. This next case is basically saying, If you basically say you can give direct money aid to help renovate some aspect of a church facility, why can't you completely renovate this beautiful congregational church, which, if it's not renovated with public funds, will go out of business? It's completely dependent upon this. And so we'll see how the Supreme Judicial Court of Massachusetts does this, decides. But this is, the Supreme Court has really liberalized the lines between church and state when it comes to direct aid. They're kind of, basically, so long as you're not paying, I guess, for stained glass windows, you're not paying for the minister's salary, so long as you can get some type of arguably secular benefit out of it, then the Supreme Court seems to be saying that that is okay, just so long as you're not funding directly religious worship or exercise. Excuse me. The other type of funding, which has been controversial on and off, isn't dealing with necessarily funding of schools and churches, but religious social service agencies. And this kind of hit the spotlight really back in the 1990s with what was called charitable choice, which Bill Clinton got behind. But let me back up from that. There's actually been a very long history of cooperation between religious social service agencies and various levels of government going back into the early 19th century. I mean, when it comes down to it, we think about the great social service safety net that we all now basically expect, even though it's not as good as it could be, was really creation of the New Deal more than anything, and the Great Society. Prior to that time, charitable organizations were primarily religious. They were private. And so many times they did contract with local communities to provide social service programs for people in need. And so the vast majority of those were, in fact, religiously affiliated institutions. Salvation Army, which is an evangelical church, very evangelical, right? But they're a major social service provider, as we all know. Catholic social services, Catholic Charities is another major one, Lutheran social services. These are very big, important ones. Ecumenical Ministries here in Oregon, which is the Protestant kind of version. They provide very important social services, and they receive grants from various governmental entities to do these social services. This has been going on for a long time. But the way of practice has always been is that they would segregate out their secular social services, foodstuffs, housing, clothing, other things, whatever the services are, right? They would segregate those from any of their religious activity, put them on separate books, so the public funds would only pay for those clearly secular things. Right? And notwithstanding that they entered into this overall ministry from a religious perspective, and they're doing it for religious reasons, that's fine, but they were not proselytizing. Okay. Bill Clinton, Democrat, he actually started changing those rules and tried to open the door for allowing for more cooperation between religious entities and governmental entities, to give more leeway for these religious entities to receive public funding, to try to create a friendlier environment for this. And so he created what was called charitable choice, which basically meant that we're going to change some of the regulations and not create presumptions that religious institutions cannot receive public fundings just because they're religious. And to a degree, I agree with that. Okay. George W. Bush, though, when he came in, he took that and he multiplied it exponentially. This is what's called the faith-based initiative. And Bush's belief is that we could not tell religious social service agencies to segregate their activities. That because they integrate their activities, this was actually discriminating against religion, to tell these religious social service agencies that they had to change hats, figuratively. And it was excluding some religious social service agencies. And so there was an agency in Texas that was in litigation initially, and then after Bush's program, it basically was allowed to get the funds. And it was about kind of job training, which is a common thing for social service agencies. And so this religious organization did job training, okay? Met 2 days a week. And so on Tuesdays, they would read the Bible. On Thursdays, they would talk about biblical principles to help you gain the character and the techniques for being a successful job applicant. And they said, we can't separate the two. The Texas Department of Social Services said, if you clean up the Thursday a little bit, we'll pay for that, but we're not going to pay for the Tuesday program where they sit around and read the Bible. Contentious for a while. The Bush administration says, no, we can grandfather this, right? So in essence, so long as it is optional on Tuesday, then we will go ahead and pay for the program. You don't necessarily have to change the reason that you're giving job skills training to people on Thursday. You don't have to change your reasoning that it is religiously based. And so it was kind of to break down these walls and to make it easier to get this funding. In the Obama administration, Obama stepped back from that, of course. He even changed the name. He no longer called it the Faith-Based Initiative. He called it the Community, what was it, something, Community Resources or something like that, and put in greater restrictions upon the way that the money would be spent on various social service agencies. We now have a new change in administration, and in fact, just today, I got an email from someone who passed on a, what do I want to call it? Call for proposals, I think it was, from the faith-based office of the Department of Health and Human Services. And they're sending this out to all of the various religious charities that have participated in various programs, to basically ask them to please contact us and tell us what existing regulations you think are troubling, and what existing regulations you would rather not see be imposed upon your ability to receive public funding in order to do these types of programs. And so with the Trump administration, I think we're going to see a switch back. Looks like we're seeing a switch back to what's been going on with the Bush administration. Then we always have ceremonial deism. And to a certain extent, maybe this is an area where it hasn't changed that much, other than the court, once again, seems to be a little bit more permissive to this. And so things like Ten Commandment monuments, this is the Mojave Desert cross, which was initially put up to honor the war dead by a private group, but then it became part of the Mojave Desert National Monument, I think it is. And they still wanted to have this up as a memorial. A famous argument for the Supreme Court several years ago where I think it was Justice Kennedy said to the ACLU attorney, well, why can't a cross honor all of the war dead? And the ACLU attorney says, well, I'm Jewish, and the cross doesn't honor my ancestors who died in World War II. It's not a ubiquitous symbol, right? But what the Supreme Court seems to be suggesting is that if you can have some arguably other than a religious reason for using religious symbolism, then it may be permissible to use religious symbolism within that particular context. And so they allowed the cross to continue to remain up. And so we're seeing more of these controversies come up to try to get some type of arguably secular reason for doing it. And let me go back to the top photo. Is this a familiar looking monument to anybody? Alabama. Who in Alabama? The soon-to-be senator from Alabama, right? Judge Roy Moore. I have a long history with Roy Moore. I won't go into all my details with Roy. But anyway, Judge Roy Moore has been doing Ten Commandments monuments for a long time, since he was a trial judge in Alabama. He put up he likes to do woodworking, and so he carved this Ten Commandments, and he put it in his courtroom in a very visible spot. So if you go into his courtroom, you saw the Ten Commandments. It was almost impossible to find anybody to, what we call standing, to be willing to litigate this, because, of course, if you're a lawyer and you appear before Judge Moore regularly, you're going to want to say, oh, Judge, I object to you putting that up here. If you're the county clerk who works for Judge Roy Moore, are you going to object to it? No. So it was hard for anybody to ever complain about this. But what Judge Roy Moore did is that he has political ambitions, and so he decided to run for the Alabama Supreme Court. And he ran for the Alabama Supreme Court in the early 2000s. He got elected Chief Justice, and Chief Justice of the Alabama Supreme Court is also the chief administrator of the court building. And so he basically controls the court building. And so he had some friends do this, I heard it was 5,000 pound, I'm not sure if that's accurate, monolith carving of the Ten Commandments, and he put it in the rotunda of the Supreme Court building of Alabama, okay? And his argument is, if this were a fully blown up picture, he surrounds the bottom part with his own selective writings, not his writings, but writings that he selected that indicate that there's a relationship between the law and the Ten Commandments. And so his justification for the Ten Commandments monument is that it's one of the sources of American law. So it's appropriate that we can honor this source of American law. Of course, this is the only source of American law he's honoring. There's no Magna Carta there, or there's no Constitution, or there's no Blackstone's commentaries. He chose which source of American law he wanted to do. But this was the argument that he could do this as a result. Well, thankfully, since he was elected to the Supreme Court, then we actually were then able to find some lawyers who'd be willing to challenge it. And we challenged it. The federal judge said, take down the monument. He said, I refuse. The 11th Circuit said, take down the monument. He said, I refuse. The court found him in contempt of court. And then they removed him as Chief Justice of the Supreme Court because he was in contempt of court. He refused to abide by the law. Okay. He then puts that monument in the back of his pickup truck and travels the country with this monument doing public speaking tours. He uses that then later after a failed attempt to run for governor. He then uses it again to get reelected to the Alabama Supreme Court. He gets elected Chief Justice of the Supreme Court again. He doesn't bring the Ten Commandments monument back with him. But then the next thing he does is, after the Obergefell decision, the marriage equality case several years ago, he orders every single probate judge in the state of Alabama, because now he's the highest judicial officer in the state, to refuse to obey the Constitution. Do not obey what the Supreme Court has said. Do not issue any marriage licenses. And so he's kicked off the Alabama Supreme Court a second time by virtue of failing to adhere to the federal Constitution. So this is who is potentially going to be elected to the U.S. Senate from Alabama next month. Or is it this month? I think it's this month. Okay, anyway. But again, the justification was that it was related to American law. The Supreme Court dealt with Ten Commandments monuments in 2005, a case I was somewhat involved with. And what I found troubling when I went to the argument was that you could see just the change in attitude, whether it's more conservative justices or not. And no one except John Paul Stevens even ventured to ask the question of, by what right initially does the government have to use religious symbolism to advance its own goals? I mean, let's not get to the second question about, is there truly a relationship between the Ten Commandments and American law? And I can guide you to a law review article I wrote on this where I show there is no relationship. But that's a debatable relationship, right? But still, the question first should be, by what right can the government start using religious symbolism? If it has alternative ways to communicate its values, why expropriate religion for this purpose? And most of the Supreme Court just accepted, at least as an initial proposition, that the government can use the Ten Commandments, can use crosses. It's the reason you do it. It's the rationale behind it. And so again, I see some changes in the way the Supreme Court has been dealing with church-state matters. All right. This is the big issue that's come up these days. Questions about exemptions from non-discrimination laws. And here we're talking primarily about gay rights and gay marriage questions. Okay. Now, there has been for a long time, Title VII is the Civil Rights Statute of 1964, which basically requires equal employment opportunity, non-discrimination in employment. And so it's been around for a long time and basically says you can't discriminate against somebody in employment on the basis of their race, religion, gender, national origin. Right? So that's been around. But they exempted houses of worship and religiously affiliated institutions under Title VII from making decisions based upon religion. That basically said, we're going to see religion is somewhat different. And so if you're a religiously based institution, then you can't discriminate on the basis of race in your employment. And here, let me back up. I'm talking about religiously based institutions. Hospitals, nursing homes, publishing houses, on and on. I mean, when it comes down to it, the majority of hospitals within the nation are religiously affiliated. And so we're talking about huge numbers of institutions that employ hundreds, if not thousands, of employees. And the question becomes, can you basically be religiously selective in who your employees are? Vast majority of hospitals don't do that, of course. Providence doesn't do that except in some very selective positions. Why? Because they're not going to be able to fill it full of just Catholic doctors and Catholic nurses, obviously, right? And they see no reason to do that. But Title VII actually allows for a religiously based hospital to do that. I was involved in a case many years ago dealing with Loma Linda Hospital, which is a Seventh-day Adventist hospital in Southern California, very well respected, well known, okay? Someone complained that they had been fired, claiming it was on the basis of his age. He was a former Army, or I can't remember now, Army or Air Force nurse, and he'd been a nurse in Loma Linda Hospital. He was also African American. So he made claims that Loma Linda had fired him on both of those grounds. Okay. Loma Linda, even though it does employ vast majority of people who are not Seventh-day Adventists, responded saying, no, we fired him because he was Seventh-day Adventist. He was not Seventh-day Adventist. And our client responded and said, you never made that as a requirement for this particular position. They responded, we're now making this a requirement for this particular position. It got resolved short of litigation. All right. But the point is what Title VII says is that religious institutions can discriminate on the basis of religion, but nothing else. But sometimes that allows them to couch an argument that it is religiously based discrimination, not some other form of discrimination, and then it becomes a cover for whatever that form of discrimination. But that's been around for a long time. Okay. Hosanna Tabor case is a case I think all of us can, at one level degree, agree with, and that dealt with, even more particularly, is there's something called a ministerial exemption to Title VII, which basically says when you're talking about who your minister is, who your clergy is, who leads your congregation, can you basically use any reason to discriminate? That in essence, we just give churches and houses of worship a carte blanche. We don't look into the reasons behind this, unlike the situation I was just talking about. And the Supreme Court ruled 9-0 and said, yes, we're going to see houses of worship are so different and so particular that even if we said to the Catholic Church, you can discriminate on the basis of Catholicism, but you can't discriminate on the basis of gender, on who your priests are. That's just crossing a line. The government should not be able to do that with its regulations. And so consequently, we give greater protection for houses of worship. Now, again, the devil's always in the details. The Hosanna Tabor case actually dealt with a school teacher teaching in a Missouri Synod Lutheran school who taught secular classes. But she did lead the students in prayer and religious exercises. And she admitted that she had felt that she had been called to her task as a teacher in a parochial school from a religious perspective. And so the church, in response, said, we consider her to be a minister in the general sense. So consequently, even though she had a disability, which would otherwise say you cannot discriminate against her, and they fired her, you cannot dismiss her based upon her disability or medical disability, the church came back and said, we have a carte blanche when it comes to this. So again, a principle I think makes sense, but sometimes it's how the principle is being applied. And this occurs also within religiously affiliated colleges and hospitals, like I said, as well. Okay. Well, what is the most recent manifestation of this? Has been two things, more than two, but anyway. One is that the Supreme Court has basically, almost inconsistently with what I'm going to be saying, this is going to sound like their attention, has said that in some ways religion is not distinctive anymore. I tell my students, I think if there's anything that you can at least say the framers of the Constitution were thinking about when they wrote the Free Exercise and Establishment Clause, is they thought religion was distinctive from other types of ideologies and philosophies. You may disagree with that, but at least it seems like it, right? I mean, the only kind of ideological framework that the founders identify in the First Amendment that is the government is somehow excluded from inhibiting or supporting is religion, right? The government can speak politically, it can speak artistically, it can speak scientifically, it can speak with multiple voices on multiple perspectives. But it seems like the First Amendment basically says, religion, you are different. Sometimes we treat you better, sometimes we treat you worse in a sense, but we do it for good reasons. But religion is different, okay? About 20 years ago, the Supreme Court started saying that there's no difference between a religious perspective and a non-religious perspective on many issues. So in essence, if you invite the Boy Scouts to come in and have access to your public school and do recruitment of your students, what are the Boy Scouts teaching? The Boy Scouts are teaching morals, right? Character education. And so therefore, you can't prohibit a religious group from coming in and having the same access to the students. They're teaching character education and morals. They're just teaching it from a religious perspective. And so what we're seeing, and Justice Anthony Kennedy has been the main proponent of this, is he basically says religious viewpoints and non-religious viewpoints are basically the same. So you can't discriminate against religious viewpoints when you allow for basically the comparable view from a secular perspective to be used. Okay, that's more of a free speech question. So that's one thing the court has done. So it's basically kind of makes it sound like religion is no different, so therefore free speech and equal protection, you got to allow religion to speak the same way. Okay. Conversely, then the court has been saying, no, maybe religion is different. And so consequently, when it comes to a religious reason not to comply with a non-discrimination law or a religious reason not to provide contraceptive coverage under the Affordable Care Act, we will give you an exemption from that law, from complying with that law, when we wouldn't give anyone else an exemption from complying with that law. Okay. I think the most tragic's the wrong word, but anyway, the worst case in recent memory is a case called Hobby Lobby. Hobby Lobby is a 500-store family-owned business with 13,000 at least employees. It is a for-profit commercial enterprise, even though it's owned by Stephen and David Green. My younger brother's name's David. No relationship. They are evangelical, and it's not a publicly traded company, all right? And so it basically means family members are the board of directors, right? They believe that certain types of abortifacients, certain types of contraceptives are sinful. So consequently, they did not want to comply with the Affordable Care Act requirement that if you provide insurance, that you have to provide contraceptive coverage. They said it violates our freedom of conscience, our religious beliefs, because if we provide coverage, we're somehow now facilitating abortion or facilitating contraceptive care comparable to abortion. Okay. As a result, they were fined by the U.S. government. It goes to the United States Supreme Court. This was just an amazing case. It actually built on a case that a lot of you have probably heard of called Citizens United. And Citizens United, several years earlier, the United States Supreme Court said that basically for-profit corporations have a free speech right to make campaign contributions. They get to express themselves politically. So they build on Citizens United, and they now say corporations not only have a free speech right, you have a free exercise right. Now, what we're talking about here, the plaintiff is Hobby Lobby. The plaintiff is not the Greens. It's a corporation doing this. But the Supreme Court said because it was a family-held business, the Greens, basically in some ways being equivalent with a corporation, which all my friends in the law school and the business school who know anything about corporate law say it's completely false, because the whole reason that you incorporate is to provide distance from yourself personally from your business, so you have limited liability, and you're making the argument that I am not the same as my corporation, I am different from my corporation. That all aside, the Supreme Court then said, well, no, basically because it offends their religious beliefs, therefore we can extrapolate that the corporation also has the ability to, in fact, exercise religion. And so consequently, this was a burden on their religion. Now, I also question the extent of the burden on religion. I kind of take an extreme view of this. I have no doubt that the Greens themselves are sincerely opposed to certain contraceptive care, sincerely opposed to abortion, and they do it from a religious perspective. My sense is, though, how are they complicit or facilitating that sinful conduct of those people, of those women who are accessing contraceptive care? How are they doing that? Including contraceptive care in their insurance policy. That's it. It doesn't cost them any more to include contraceptive care in the insurance policy. It's folded in with all the costs. So there's no monetary costs that they're having to incur as a result. There's something you may have heard about called the federal HIPAA laws. And the federal HIPAA laws basically says that your employer cannot, even if your employer is providing insurance coverage for you, has no right to know exactly what prescriptions you are accessing, to know your medical history unless you're willing to divulge that medical history. So all the Greens knew is that they would be forced to have in their coverage plan coverage for contraceptive care. They don't know from one day to the next if any female employer is actually getting contraceptives. They have no right to know that, and it doesn't cost them any more money. I think the burden is pretty insignificant here. I think it's speculative burdens to a certain extent. And so even if a corporation can pray, I raise concern about the level of the burden that goes on there. This even went up even further in the Little Sisters of the Poor case. There's a group of nuns. They have taken so many, I'll be flip. Anyway, every photograph you see of them, they're really nice, friendly, smiling, happy people, because that's what their lawyers are doing. And they're nice people, I have no doubt. And the question became, they were a religious institution. They were exempt from the ACA contraceptive care coverage. But to be exempt from the ACA contraceptive care coverage, you had to file a piece of paper with Department of Human Services that says, we want to be exempt from it, therefore our employees can get the coverage someplace else. That triggered allowing the government to pick up the cost of contraceptive coverage. And the Little Sisters of the Poor said, we can't even file that paperwork. We can't even tell you that we want to be exempt, because if we tell you want to be exempt, then that means someone else will then pay for this contraceptive care. Therefore, we are complicit in our employees getting contraceptive care. And of course, all the photographs were of the Little Sisters of the Poor. They're a Denver-based group. And kind of like, this is ludicrous. Why are we forcing a bunch of nuns to get contraceptive care, right? But the point is, they run nursing homes. And almost all of their employees in the nursing homes are lower educated, lower income women who aren't Catholic, who can't afford to pay for their own contraceptive coverage. So it's not these ladies who are going to get the pill. It's their employees are going to get the pill. And they said it was a burden on their religion to even tell the government, such that it facilitates someone else getting the contraceptive coverage. That was before Justice Gorsuch. It was a 4-4 tie on that. Okay. That case is still now back in litigation. It'll be going back up to the Supreme Court. But 4 of the justices were willing to say even that is a burden on religion to do that. My last case, Masterpiece Cakes. And that's what's currently before the Supreme Court. And these are the famous cases that are now percolating throughout the country. We had one here in Portland. Sweet Cakes, Masterpiece Cakes comes out of Colorado. We've had Arlene Flowers, florist out of the Washington area. Elaine's Photography out of New Mexico. What's in common with all of these are businesses, small businesses that are run by conservative Christians who disagree with gay marriage. And as a result, they don't want to serve gay couples in whatever capacity, whether it's making a wedding cake, whether it's taking wedding photography, whether it's providing flowers for the wedding. Okay. And consequently, they are running up against, and this is kind of one of the ironies I tell my students, even though the Supreme Court, how long has it been, 3 years now, found that there's a constitutional right to marriage equality, that does not affect each individual state's non-discrimination laws. And less than half the states actually have laws that says you must serve someone, if you are a public accommodation, your business, anybody who comes in and not discriminate on the basis of race, religion, gender, and sexual orientation. Oregon is one of those states. Colorado is one of those states. Washington is one of those states. So these are non-discrimination laws that basically say if you're operating a business, you can't pick and choose who you serve based upon race, religion, gender, or sexual orientation. And so Mr. Phillips, who runs Masterpiece Cake Shop, he is arguing that in order to make a cake, he's engaged in expressive activity, and consequently they're forcing him to advocate or promote a lifestyle with which he is religiously opposed to. So consequently, this violates both his free speech rights and his free exercise rights. This is the case the brief I participated in, we just filed on Monday. This will be argued at the Supreme Court next month. And it's a guess on how it's going to turn out. It's going to be 5-4 one way or the other, I can tell you. But in essence, the argument is that I get to, when I run my business, kind of create a protective bubble zone around me and can object on certain, basically on religious grounds, whether I comply with general benevolent regulations that the local government has decided are important. Okay. So this is how church state has changed over the years, and you can kind of tell where potentially it may be going. Okay. I could probably do this in about another 15 minutes, another 5 minutes on this, and then we could do question and answer. Okay? Maybe I can't do this in another 5 minutes. Okay. I have to leave by 3. So, unfortunately, I'm sorry. It's just picking my daughter. Okay. Let's talk about religion and politics. Okay. I've had this bumper sticker for years. It actually goes back to the Reagan administration, with a clear identity of the GOP with Republican Party, with evangelical Christians, the rise of the religious right. We're all familiar with that story. Okay. What is interesting is what's happening today with Trump. I can't speak for somebody, so forgive me, but I'll go ahead and make these statements. As a historian, somebody who studies this very closely, follows this very closely, I personally think, professionally think, that Trump is probably the most irreligious president we've had since Richard Nixon. Okay, it's just, I find it kind of interesting and amazing, the fact that the close alliance that has arisen with President Trump, with the evangelical base. He received somewhere between 70 to 80% of the evangelical vote for president, and this is a month and a half, less than a month after the Access Hollywood tape came out about him groping women and basically sexually harassing, if not engaging in criminal activity. And the degree that many evangelical Christians just kind of put that to the side, forgave him of this, right? I don't know how religious he is. I was just reading some background on him, in which all this came together when I started seeing this, is that Trump was raised nominal Presbyterian. He was confirmed, went through confirmation in the Presbyterian Church. He generally has not been a very active attendee of any type church. The church that he actually became attracted to is a church in New York City called Marble Collegiate Church. Anybody ever heard of Marble Collegiate Church? Whose church is that? Norman Vincent Peale. Norman Vincent Peale, The Power of Positive Thinking, right? The beginning of the prosperity gospel. And it's a type of theological perspective framework that basically said, God wants you to be successful. God wants you to be happy. Don't worry about these annoying doctrinal problems that are contained in the Bible. Don't worry about sinfulness, that kind of stuff. You know, basically, this is what God wants you to be. Feel-good religion. And so he was attracted, and he actually became a member of Marble Collegiate Church. Norman Vincent Peale actually officiated at his first marriage and officiated at the funerals of both of his parents. And so he has had a close connection with this kind of idea about where religion kind of fits in relation to success, because Norman Vincent Peale wrote some books about businessmen being successful is evidence of kind of getting in that kind of right relationship with God. Okay. He's been uncomfortable, though, with evangelicals. There's this joke going on out there that when he talks to somebody who's just met with the vice president, he says, did he ask you to pray with him? That he still doesn't really kind of understand a lot of what you think would be basic Christian knowledge. Remember the faux pas when he was running, and he basically called 2 Corinthians 2 Corinthians or something like that. Yeah. He was asked what his favorite passage from the Bible is. And his favorite passage from the Bible is an eye for an eye instead of turn your other cheek. I mean, there are all these kind of nice little snippets that exist out there that kind of give you a sense that this is probably not the most religious person in the world. Okay. But what he has done is that he has, my clicker, he has done several things from a religious perspective. The first thing, of course, was the Muslim travel ban, right? That he identified certain countries for non-admission to the United States based upon the religious character of those nations. Okay. That was struck down a couple of times by federal circuit courts, and we had briefs pending at the Supreme Court back last month, and the Supreme Court dismissed the cases because the cases are now moot. Those versions of the travel ban have now exhausted. And so we start over kind of from square one again on this question, right? But there was information clearly during the election and post-election where he was basically saying, I'm going to ban Muslims. Nothing like that really had ever been done in our history. Probably the closest that anything has really come to that has been when President Buchanan sent troops to Utah to destroy the Mormon church because they were Mormons. That's about as close a historic analogy as we've ever had to the president using the power of the presidency to basically say, we are going to single out a particular religious community for disfavored treatment because of their religion. Okay. In May, he did an executive order promoting religious liberty when in essence was just more or less kind of window dressing. Basically said, you can't discriminate against religion in any kind of regulation. Well, I think most people agree. You can't discriminate against religion in any regulation. Basically said you have to treat religion like you treat any other entity that you're regulating, which has been the law more or less. But he did this on the National Day of Prayer, and here he is with some of the little sisters from the poor who were at the White House with him to do a nice photo op. But in essence, he has made a lot of statements. He was at the Value Voters Summit just last month, where he's talking about Christians being a persecuted class, how we're disfavored, and so consequently, I will do everything I can to ensure that your religious rights are being protected. And most recently, the Department of Justice and HHS have come out with some new rules about ensuring or ratcheting up the protection for conscientious objection from any type of regulation that the government's imposing if you have a religious base, irrespective of whether you're a religious institution or a for-profit institution. My cynical view is, if you hadn't told I'm cynical about this already, is that as part of the difficulty that Trump is having in getting other types of domestic legislation through, that this is really relatively easy place to support your base. That in essence, these are relatively cost-free. You don't have to go through a Congress that's dysfunctional, right? And so what does he refer to? I appointed Neil Gorsuch to the Supreme Court, who's a religious conservative, right? I've done all these other things, which most of these have really no substance behind them. But these don't require anything other than him doing executive orders or rules. So consequently, these are relatively cost-free in the political process. He doesn't have to use political capital, but then they reap a significant amount of a benefit for a significant part of his base. So as a result, as recently as just this last month, Jerry Falwell Jr., the president of Liberty University, he basically admitted to a reporter that I don't think Trump is very religious, and I don't support him because he is evangelical Christian. I support him because he's going to give us what we want. And so, to me, I find that kind of troubling. I had never had any doubt that George W. Bush was a devoutly religious person, even though I disagreed with some of his policies. This starts to seem like it's more or less what Madison warned against us a long time ago, is manipulating religion for the political purposes, making religion an engine of civil government. And so, we'll see. Okay, apologize, I went a long time. Questions?
Professor Green. I'm Bob Muir. The Trinity Lutheran case, if I understand it, we had a report on that a few days
you did?
ago. Okay. As I understand it, the Blaine Amendment was rendered ineffective because of a holding that the discrimination against that church with regard to that grant would restrain the free exercise of religion. That's the part I don't understand. How free exercise is impaired by not receiving funds for a playground.
Well, that's what's happened. They've said it's now religious discrimination. To a certain extent, it's kind of turning the constitutional doctrine on its head, right? As I tell my students all the time, when I say that the framers, and I'm not an originalist by any stretch, but you still go to the text. All of us are originalist at one level, right? And if you look at what they were thinking about religion being something distinctive, what that means is sometimes maybe we protect religion in ways we don't protect other types of conduct. So in essence, a kid gets to wear a yarmulke at a public school because that's what their religion requires, even though you don't allow other kids to wear hats. Or I worked on a religious accommodation law here in the Oregon legislature, right, where it basically required employees to allow Muslim women to wear their hijab in their workplace, okay? That's what their religion requires. So sometimes we protect religion more. But then it also means in other contexts, we don't give religion all of the benefits that we want to insulate religion so it can be independent from the government, right? What the Trinity Lutheran decision seems to suggest, though, is if you do that second thing, you're now discriminating against religion. So it sounds like it's reading the meaning out of the no establishment principle, because when you think about it, every time you enforce the no establishment clause, you're enforcing it against a religious recipient receiving a government benefit. And to me, that is counter-textual. It's reading all meaning out of the establishment clause.
Hi, I'm a healthcare professional, so I'm curious from that point of view, but the HHS regulations, the conscientious objection, what do you see as some of the implications of that being? Yeah. Like for a healthcare professional, like a pharmacist stepping away?
Pharmacist has been the other thing too, yeah. You know, I believe in accommodating religion if possible, so long as it doesn't transfer burdens to someone else, right? And so consequently, you know, if you're a mom and pop pharmacy, which my wife uses a very small pharmacy here in town, mom and pop pharmacy, right? And they have religious objections to providing certain types of, you know, morning after pills, something like that. And there is a pharmacy next door which would be willing to provide that. Something inside me says, yeah, maybe accommodate that religious need, right? But these become very contextual, right? What if you're the only pharmacy in Eastern Oregon and you object to this, right? So I think part of the formula is how burdensome is this on the individual who's otherwise needs access to this information, this material. Now, you could apply that to a certain extent against the cake shop scenario, against the wedding photographer scenario, whatever. Right? You can go to another cake shop. And as much as I've been very supportive of the LGBT community, I sometimes think some of these cases could have been avoided because I think sometimes these are test cases. Right? I do, as a law professor, also understand the danger, though, of carving out exceptions for public accommodation laws, right? So it's not necessarily an easy question, right? But again, I'm not a business person, I've never been in business, so I can't speak for it. But I think if you voluntarily enter the free marketplace to engage in business transactions for-profit, non-religiously motivated reasons, then you know that you are going to be bumping up all the time against regulations you disagree with. I hate OSHA. I hate these other health safety requirements. I hate having a bathroom that's accessible. These all cost me money, right? Live with it. That's the requirements about operating a business. And so on the same level, I think that when you're operating a bakery, a wedding a photography place, you know there's going to be a high clientele that's going to be related to some of these particular areas, and you just have to accept that. Let's put it this way. Remember the Kim Davis argument? She was the county clerk in Kentucky who refused to do marriages because she objected to it. In my previous life, many years ago, I was a magistrate judge in Alaska. And one of the things I had to do was perform weddings. And I can tell you, there were a lot of weddings of couples who came before me who I felt deep down, I don't want to marry these people. They're going to, and I actually had some in front of me within 6 months getting divorces, I can guarantee you. I mean, they're squabbling, come on, I would rather not. But I never at once thought when I was signing that wedding certificate, I was endorsing that couple or endorsing their lifestyle, right? It's part of the business. And just because you're making a wedding cake doesn't mean you're endorsing that lifestyle. It's part of the business. Healthcare may be a little bit different. I would certainly respect that if you're a Catholic or an evangelical Christian, we're not going to force you to be engaged in abortion providing, right? There's some things, because to me that's more direct. You're the agent of change. Remember I was talking earlier about some of these questions about, are you complicit in the sinful activity? Are you facilitating the sinful activity, right? If I believe abortion is a sin and I'm a doctor, and you force me to do an abortion, I am facilitating that sinful activity. And if I believe in it, then I will suffer consequences when I die, right? Okay. That's very different, I think. But the thing is, we do carve out. It's been since the 1970s, after Roe versus Wade, we made an immediate carve out that basically said Catholic and other religious hospitals don't have to provide certain services which they are conscientiously opposed to. So we do it for religious institutions. The problem is how far do we start going into for-profit businesses?
Hi, this is Jim. A quick question. I lived in France for a while, and I was always amazed at the difference in approaches. I mean, in writing, I think laïcité or secularization is the same as separation of church and state. But in France, they take it much more seriously. And when I ask my French lawyers about that, my friends, they say, well, in France, it's legal. It's the law. And it's in our Constitution in Article 1, and you cannot escape it. And I think to myself, what's the difference? It's in our Constitution as well.
Yeah, and as I've shown you, it's in our Constitution, but sometimes it doesn't seem like the Constitution is operating the way that we think it might otherwise operate, you know, that we can find wiggle room around it. Yeah, we can go a long discussion about the French Muslim garb ban, you know, of whether that is a good idea. I actually think it's not a good idea, but it's interesting. They take laïcité one direction, but then they still have religious symbols in some of the public schools, right? And so there are questions on kind of where it goes, and it may be different for each community depending on their traditions. Yeah.
I guess there's time for one more.
Sure.
And
Sorry.
I actually have a question. Oh, I'm sorry. Was there a hand? Okay. Well, what do you think about the continuing celebration of baccalaureate services to do with high school graduations? That's a religious service blessing the graduates.
Okay, depends on how you define it, okay? I think a baccalaureate is a religious service. It's not a graduation, okay? And so what I'm meaning is I am fully supportive of there being a religious baccalaureate service that is held in a local church. I really don't like them being held in the public high schools. A local church that is optional and that does not merge with the graduation exercise. And I'm even okay about if they want to include it in the brochure that the senior class distributes to senior class about all the senior class activities going on. You know, we're going to have a dance one night. We're going to have a party the next night. We're going to have a baccalaureate the next day for those who are not sober enough, or whatever. And then we're going to have the graduation the next day, right? I have no problem with including it in there, but let's just not merge them. So that's why I don't like invocations, benedictions in a public high school graduation ceremony. Let the kids who want to be religious go to the baccalaureate.
Okay, we've run out of time, and so has Professor Green. Let's give him some thanks.
Thank you.